Hello everyone and welcome back to our channel Drishti IAS English. My name is Pragya and in today's episode of Polity Primer, we are going to discuss a very interesting topic, that is the focal point between the judiciary and the parliament. The title of our today's discussion is the ninth schedule of our Indian Constitution. In this discussion, we will be studying about what is the ninth schedule of the Indian Constitution. We are also going to see the judicial review of this ninth schedule, whether it is possible or whether it is not possible. And we are also going to see a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's topic, the Jharkhand State Legislative Assembly has brought a bill, and this bill seeks to reserve 77% of the seats in the vacant government jobs. The controversy has arisen because the Jharkhand State Legislative Assembly wants the central government to put this law under the ninth schedule. So this brings us to the moot question of our today's discussion, that what is the ninth schedule of our Indian Constitution? Let us examine. So if I talk about the ninth schedule of our Indian Constitution, it is basically a schedule that has certain central law and state laws, a list of central laws and state laws which cannot be challenged in courts. Kindly remember this. It will help you in understanding what I am saying in my further slides. So, let us first understand the historical background of the enactment of the ninth schedule and how it came into our Indian Constitution. So, what happened during the British Raj? There was this concept known as the zamindari system. Zamindari system. And Lord Cornwallis was the father of this zamindari system. Lord Cornwallis. He introduced the Permanent Settlement Act. Permanent Settlement Act. And due to this, the farmers who cultivated their lands were not the real owner of their lands. So, who was the real owners? The zamindars, zagirdars, etc. So, when we gained independence, this abolition of zamindari system became a national issue, because independent India had some issues. Okay, we did not have enough development. We were fairly a very young country, and that is why there were nationalistic sentiments, and the government wanted to do reforms, because as you know, the LPG policy or the liberalization, privatization and globalization policy came in 1991. Before this, the government was responsible to conduct developments. So, to conduct these developments, the challenge was the Right to Property Act, because at that point of time, it was a fundamental rights. So, the government was getting very difficult for the government to acquire lands. Why? Because whenever the government tried to acquire land, the petitioners, whoever whose land was acquired by the government, approached the Supreme Court that how can you deny my Right to Property Act? As it is my fundamental right, you cannot deny me right to property. So the government had to come up with a solution so that it could, develop the country. So the government then enacted the very first Constitutional Amendment Act of 1952, and this inserted 3 articles in our Indian Constitution: Article 31A, Article 31B and Article 31C. And this also added the ninth schedule to our Indian Constitution. So, what is this ninth schedule? Ninth schedule is basically a list of central laws and state laws, and this list is specifically barred from judicial review. That means the judiciary cannot scrutinize whatever the laws you are putting in the ninth schedule. But what happened after this? The government started putting unreasonable laws in the ninth schedule. Let us understand this by a help of an example, that supposedly this is a jar, okay, and this jar is known as the ninth schedule. So there were some important laws which were helpful for the land reforms that the government was planning to conduct, because abolition of zamindari system was very essential if we wanted to have the development in our country. So apart from these land reforms acts, there were other unreasonable acts placed in the 9th schedule just because the government wanted to protect them from judicial review. Now the judiciary awakened that what is happening, they are not allowing us to examine or scrutinize the 9th schedule, and on the other hand the petitioners are alleging that okay, this is turning very unreasonable. They are also, violating our fundamental rights by placing unreasonable acts in the 9th schedule, and hence the judiciary awakened. And we'll understand this in our further slides, that whether judicial review of 9th constitution is possible or not. But let us examine the 3 articles, that is article 31A, 31B and 31C. So this article 31A, 31B and 31C were inserted by the first Constitutional Amendment Act, and they helped the government in conducting the land reforms. So article 31B specifically also has a retrospective operation. What do we mean by retrospective operation? For example, let us understand, this is this act or this is this article A. For example, okay, so then it will be having an enactment date and an enforcement date. So from the enforcement date, it will be applicable prospectively. What is this prospective application? That it will be applicable to those acts which are done after the enactment of this article or law A. It will not be applicable to the enactment, on those acts that have already occurred before its enactment. Okay, so these are some acts and they have already occurred before the enactment of this article A or some law or some section. But what happens in this case is the article 31B was also applicable on these acts which were done before the insertion of article 31B, and that is why we are saying that this article 31B has a retrospective effect. That is, if laws are inserted in the 9th schedule after they are declared unconstitutional, that means the Supreme Court has examined those laws and declared them as unconstitutional because they are either violating the fundamental rights or the basic structure doctrine. But the article 31B stated that even if they are declared as unconstitutional by our Indian Supreme Court, they are considered to have been in the schedule since their commencement, and thus they become valid. So I hope you understood what I'm saying, that just because they were there in the 9th schedule, and article 31B has retrospective operation, and that is why even if they are unconstitutional, they became valid. So this was again very problematic. Although article 31B excludes judicial review, the apex court has said in the past that even laws under the 9th schedule would be open to scrutiny if they violated fundamental rights or the basic structure of the constitution. So as I was explaining to you before also, that the judiciary suddenly awakened that what is happening, they are neither allowing us to examine the 9th schedule, nor they are allowing us to challenge, and they are also putting some of the laws which are declared unconstitutional by us, and then also they are in 9th schedule, and they are saying that those laws are also valid. So this opened the gates for judicial review of the schedule of our Indian constitution by the judiciary. And finally it was held by the Supreme Court that if they violated fundamental rights and the basic structure doctrine, which was enacted in the Keshwanand Bharti case. Keshwanand Bharti case. So after the evolution of the basic structure doctrine in the Keshwanand Bharti case, the laws which are placed in the 9th schedule could also be judicially reviewed. And you should remember that judicial review is a part of the basic structure doctrine, as has been declared by the Supreme Court in the Indira Gandhi versus Raj Naren case. Indira Gandhi versus Raj Naren case. So this judicial review in itself is a part of the basic structure doctrine, as has been held by the Supreme Court in the Indira Gandhi versus Raj Naren case. So this brings us to the another question of our today's discussion, that whether laws in the 9th schedule are judicially reviewable or not. Let us examine. So the story moves forwards from the Keshwanand Bharti case, and the Supreme Court in the seminal judgment of I.R. Coello versus State of Tamil Nadu dealt with the ramifications of the fictional immunity granted by the Article 31B. So as I was explaining to you before also, that Article 31B had retrospective operation, and even those laws which were unconstitutional were also becoming valid just because they were placed in the 9th schedule of our Indian Constitution. The Supreme Court ruled that laws placed under the 9th schedule can be challenged on the ground of violating the basic structure of the Constitution. So after the judgment, after this date, especially April 24, 1974, this is the date of the Keshwanand Bharti case, and after this date, any of the laws which are placed in the 9th schedule could be scrutinized by the judiciary under the power of judicial review, and this has been held in the case of I.R. Coello versus State of Tamil Nadu. Now let us see some of the important observations that the Supreme Court has made in this case. So the first point is, a law that abrogates or abridges rights guaranteed by Part 3, that is the fundamental rights of the Constitution, may violate the basic structure doctrine or it may not. So what is it stating? Let me explain by a help of a flowchart. So see, there is this law, okay, and it is saying that it may violate part 3, that is the FR or the basic structure, and it may not violate it, okay, may not violate it. So if it doesn't violate, then there is no problem, okay, that law is valid. If whether you put it in 9th schedule, whether you include it by amendment or by any such means, that law will be valid, and if it is challenged, then the Supreme Court will examine it on merits and then decide that whether it is constitutional or not. But just because it is a law and it is not violating a fundamental right or the basic structure, the Supreme Court prima facie considers it to be valid. But what about those laws that may violate fundamental rights or basic structure doctrine? So the Supreme Court says in this case that those laws which violate fundamental rights or basic structure of our Indian Constitution, even if you insert them by way of a constitutional amendment, and even if you insert them by the utilizing your power under the 9th schedule, they can be judicially reviewed. Kindly note this point, that they can be judicially reviewed. They can be challenged, and if it is found out that they violate the fundamental rights of basic structure doctrine, then they will be held invalid by our Honorable Supreme Court. So this was the first point of observation of the Supreme Court in the I.R. Coello versus State of Tamil Nadu. Then if you talk about the second point, that if former is the consequence of law, whether by an amendment of any article of Part 3 or by an insertion in the 9th schedule, such law will have to be invalidated in the exercise of judicial review power of the court. So this is what I just explained to you, that if any law is violating the fundamental rights or basic structure doctrine, even if you insert it through a constitutional amendment or by utilizing your power in the 9th schedule, they will still be held invalidated by the power of judicial review by our Indian Supreme Court. The Supreme Court also held in this case that the constitutional validity of the 9th schedule laws will also be challenged, like examined on the touchstone of the basic structure doctrine after the Keshwanand Bharti case. Okay, and applying the direct impact and the effects test. So what is this direct impact and the effects? So if it is directly impacting the fundamental rights or the basic structure of the Constitution, the Supreme Court will again examine that is it violating the fundamental rights or the basic structure of the Constitution. If yes, invalid. If no, okay, let it pass. We'll see when it is challenged before us separately. So the Supreme Court was very clear in this regard that you cannot insert any such law in the 9th schedule which violates the fundamental right or the basic structure of our constitution, especially after the April 24, 1973, the Keshwanand Bharti case. Okay. So the actual effect and impact of the law on the rights guaranteed under Part 3 has to be taken into account for determining whether or not it destroys the basic structure. So you will not see just what is the direct impact. Direct impact will be examined, but you will focus more on the actual impact of the law. That whether is it actually violating the fundamental rights or the basic structure of our constitution. If yes, definitely that law will be held invalid, as has been observed by or held by our Honorable Supreme Court in the IR Coello case. The Supreme Court also placed a restriction on the applications of Article 31 Clause A, B, C. It said that it could be utilized only for two things. Firstly, you will acquire the land for only public good. Acquire the land for public good. Okay, and even if you acquire the land, you'll have to provide compensation. So these restrictions were also placed in this case in on the application of Articles 31A, Clause A, Clause B and Clause C. Okay, so the Supreme Court also said that the said law, whatever law is placed in the 9th schedule, will also be examined on the touchstone of the golden triangles of our Indian Constitution, that is 14, 19 and 21. And if it is found that they are violative of this golden triangle as well, then also they will be held to be invalid, because this golden triangle of Article 14, 19 and 21 also forms the part of the basic structure of the Constitution. So just understand that simply that any law, whether you are enacting it by way of an amendment or you are utilizing your power under the 9th schedule, if the Supreme Court finds that they violate the fundamental rights or the basic structure or any part of the basic structure of our Indian Constitutional or the foundational values of our Indian Constitution, then definitely the Supreme Court has the power of judicial review over them, and definitely they will be struck down and will be held as invalid. So this was the crux of the observations and the judgment of the Supreme Court in the IR Coello versus State of Tamil Nadu. I hope this was clear to you. Okay. So basically we are examining the impact of the law. Impact test is used to challenge the validity of the law. If there is this impact that they are violative of fundamental rights and basic structure, definitely they will be held to be invalid. So this was all about the 9th schedule of our Indian Constitution. We understood that the 9th schedule of our Indian Constitution was inserted in the Indian Constitution by the First Amendment Act, and it also inserted 3 articles, Article 31A, B and C, and these articles are time and again modified to, there is a constant tussle between the Parliament and the Supreme Court. So whenever an adverse judgment comes against the Parliament definitely modifies all of these articles and states that they should be free from judicial review, and these articles are still an exception to the fundamental rights that are given to us under Part 3 of our Indian Constitution. So this was the crux of our today's discussion. If you ask me the present status of right to property currently is a legal right. Currently is a legal right under Article 300A of our Indian Constitution. Okay, so it is no more a fundamental right. It was abolished as a fundamental right by the 44th Constitutional Amendment Act of 1978. So finally it was abolished as a fundamental right, and you know the consequences. Now the Parliament has the power to modify your right to property. It is just a legal right. You can even be deprived of your property, but always remember the government has to do it for public good, and you will receive a compensation if you are deprived of your right to property. So this is the current status of the right to property, that it is a legal right and not a fundamental right. So this was all for today. Now let us discuss a practice question for your prelims examination. So The question is, consider the following statements. Your statement number 1 is, the 9th schedule of the Indian Constitution was added by the First Amendment Act. Your statement number 2 is, it is not subject to judicial review. Which of the following statements given above are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. Kindly drop your answers in the comment box below. Now let us analyze the practice question for your mains examination. So the question is, what was held in the Coello case? In this context, can you say that judicial review is of key importance amongst the basic features of the Indian Constitution? And this has been asked in 2016. That means it is a PYQ. So firstly, you will write about what is the 9th schedule. You will write about the first Constitutional Amendment Act. As the history I have explained, you will explain that it was very necessary to abolish the Zamindari Act. Zamindari provision that existed in India during that times, and the government was responsible for conducting developments as well. So it was the need of the hour, like protecting some land reform laws from judicial scrutiny, because at that time right to property was a fundamental right. So you could directly go to the courts for enforcement of your right to property. So you will write all of the points which I have explained today. You will write whatever it was held in the I.R. Coello case, as I have discussed in my discussion today. Then you will come to judicial review. You will examine what is judicial review, that if a law is made by the legislature, judiciary as the protector of our Indian Constitution, as the interpreter of our Indian Constitution, can scrutinize those laws if they violate our fundamental rights or the basic structure of our Indian Constitution. You will also write the power of judicial review is also in itself a basic feature of our Indian Constitution, as has been held by the Supreme Court in the Indira Gandhi versus Rajnarain judgment. And you can conclude holistically that, okay, some reforms are necessary for the government to make, and that is why 9th schedule is also necessary. But yes, you know, what cannot be done directly should not be done indirectly. This is the doctrine of colorable legislation. Remember that. What you cannot do directly, you cannot even do indirectly. So whenever you will try to do it, the Supreme Court is watching you. So this is all of this, you can conclude that you can have a holistical conclusion to this question. Okay, I hope this session was insightful for you. If you found the today's discussion to be helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.